Advocates 101. We did part 1 back in July, and we are going to finish it up today. Thank you all for coming back. If you weren't able to be here for the first one, we do have it on our YouTube channel. So my name is Amy Eisenor. I'm the Senior Staff Attorney here at Standpoint. Standpoint is a nonprofit organization, and we provide over-the-phone legal advice to victims of domestic or sexual assault, advocates that work with them, attorneys that represent them, and anyone else that's involved with their case that has legal or advocacy questions. We have 5 different attorneys here that have specializations in different kinds of law. We also have 1 new attorney who will be on a LAV program representing clients in 1 particular county. So we're excited to have new advocates and new attorneys since we were last here. And please call us if you have questions. And thank you again for joining us for part 2 of the sexual assault program for advocates. After Ty starts us off here, I will review briefly and quickly what we went over in section 1. And you can always, again, go back to that YouTube channel and review it for your own recollection. And then we'll spend a little more time starting from the trial and moving forward. Go ahead, Ty.
All right, good afternoon and welcome again. I am Ty Sinavan, Advocate Support Program Manager at Standpoint. My role today is going to be to help facilitate the webinar with Amy. If you have any questions, please type your questions under the questions tab in the control panel, and I will let Amy know and she'll answer your questions throughout this webinar. I did speak briefly with Amy before we started this webinar, and she did say that she really wants to get to your questions. So you know, please ask them, type them in, and I will just jump in as appropriately while Amy is talking. But before I have Amy start her presentation, I do have a few questions that I want all of you to answer, and this will help Amy to know the audience that she is presenting to. I'll give you about 2-3 seconds to answer those quick poll questions, and then I'll share it with everybody. So the first question is, how many years of experience do you have as an advocate? And just select one. Okay, I'll give you like a couple more seconds to vote. Okay, so I'm going to go ahead and close that question now. And Amy, it looks like we have 13% of people have been an advocate for less than 1 year, and 25% 1 to 3 years, 13% 3 to 5, 38% 5 to 10 years, and 13% more than 10 years. So we do have a pretty seasoned staff. Okay, I'll close that one out. And the second question is, how many sexual assault cases have you helped a client with in the criminal process? Okay, so I'm going to go ahead and close that as well. 22% haven't. 1 to 5 cases, 33%, and 11% 5 to 10 cases, and 33% more than 10 cases. Okay, and the next question is, what concerns have you experienced when working with law enforcement? Lack of response, lack of understanding, not sensitive to victims, not willing to work with advocacy, or you have no concerns with law enforcement at all. When I see that the majority of you have voted, I will close out the question and share the results. Okay, I'm going to go ahead and close it and share. So it looks like 13% are concerned with the lack of response from law enforcement, and another 13% with lack of understanding. 25% feel like law enforcement aren't sensitive to victims, and another 25% say that their main concern is not willing to work with advocacy, while 25% do not see any concerns right now. Okay, and we have another question. I'll launch that. Then this one is addressing prosecution. What concerns have you experienced when working with prosecution? Lack of response, lack of understanding, not sensitive to victims, not willing to work with advocacy, or no concerns. Okay, I'll close it out. And it looks like a majority, 44%, don't have any concerns with prosecution right now. And 22% are concerned with a lack of understanding, and another 22% not sensitive to victims, and 11% are concerned with the lack of response from prosecution. Okay, we have one final question, and that is, how many successful prosecutions to conviction and sentencing have you experienced? So if you haven't any, go ahead and click none yet. Less than 5, 5 to 10, more than 10. Okay, I'm going to go ahead and close it and share. And it looks like none in less than 5 years has, or less than 5 cases has 33% each, and then 5 to 10 cases is 11%, more than 10 cases is 22%. Okay, well, thank you for your responses to that. Let you all know that this webinar is being recorded, and I will upload to our YouTube channel in the following week. I will also email the recording out on our listserv as well. Our channel on YouTube is Standpoint MN for those that have never gone to our YouTube to access the webinars. We do upload all of our webinars into a YouTube page. It's a resource for advocates, and we want you to utilize that. If there's any other topics that you would want us to train on, we are working on our 2019 webinar series topics right now. So please email me, let me know what you would like us to train on. That's all that I have, Amy. You want to go ahead and get started?
Yeah, great. Thank you, Ty. Once again, welcome back. We're going to whip through the beginning part quickly, and we'll start on slide 24, going more into detail starting at the trial stage. So again, my name is Amy. Thank you for joining us, and we'll be talking through the criminal prosecution of criminal sexual conduct cases. And I'm happy to hear we have lots of seasoned advocates listening, so I want to be as mindful of your experiences and your questions as possible. So please do send them to Ty as we're going. I want this to be the most beneficial and interesting to you as possible, and want to discuss topics that you find most relevant. So we talked last time about the definition of criminal sexual conduct in Minnesota under our criminal law definitions. We talked about the difference between penetration and contact, and then the terms and elements that go into the crime for first and second degree. We talked about how first and second degree elements are consistent, and that the difference is first degree involves penetration into the anus, vaginal area, or mouth of the victim, and contact is contact with any private body part of the victim that doesn't involve penetration. Similarly, with third and fourth degree is penetration and fourth degree is contact, and then the separate elements are considered to make it this level of offense. Fifth degree is the non-consensual contact and other disorderly crimes, inappropriate exposure, and other things that we don't always consider as rape, but we consider more of a sexual assault kind of offense. We talked about the definition of consent, which is defined in Minnesota Statute 609.341, and the defenses that are available and not available regarding consent. We talked about the difficulties in prosecution and why law enforcement and prosecutors have so much specific things they have to consider when looking at whether a jury will find a defendant guilty beyond a reasonable doubt. We talked about the CSI effect and how people have expectations from watching TV and expect victims to behave in a certain way, expect certain evidence to be available. That's not always the reality that we face when we're working with our clients. We talked about all of the different kinds of remedies available to victims, and in this webinar, we're focusing primarily on the criminal court aspect of the remedies that they have. They can decide not to report to anybody, and we talked about what different resources are available to them, even if they don't ever tell a detective, law enforcement, or a hospital. But they come to us instead as advocates to seek assistance and help after a traumatic event has happened to them. We talked about what the initial process looks like if they do decide they want to report to law enforcement, what the initial report looks like, typically with a patrol officer, what kind of information they need to provide and what kind of information will be provided to them, how we can best advocate for them through those steps in the process. And for advocacy, we always are aware that the victim is in an active state of trauma if they're quickly reporting an event that happened. They may need time to sort it out. They might have significant feelings, and we have lots of information about the psychological impacts on and the physiological impacts on the brain of trauma, and that's a different webinar. But we talked about how talking with the victims about anything, even if they think that they might be in trouble for something, how important it is to tell the truth when they're reporting if they choose to talk to a law enforcement officer. And our victims do tell the truth, but sometimes they want to hold back some information that they think is shameful or embarrassing, or they don't want other people to know about, and how we can talk them through that and explain to them why it's important and why it's important for the law enforcement officer as well as for their case in the long run, that they're as honest with us and with the people working with them that they can be. We talked about a more formal statement given to law enforcement, which is typically with a detective or an investigator. We talked about going over the goals of this interview with the client prior to meeting with law enforcement so that the victim knows what to expect. We have done lots of conversations with law enforcement, and we have relationships with them, particularly in the smaller communities that you guys work in, and victims don't know what to expect. They don't have regular contact with law enforcement. So talking with them about what the role of the officer is and what our role is how we can be present for them and support them, but that we won't be talking for them in that interview. We talked a lot in the last webinar about the investigation process and how law enforcement goes about identifying other witnesses, what kind of other exhibits or evidence they can collect, taking photographs of the crime scene and evaluating how they want to handle the investigation with the defendant, whether they want to arrest the defendant immediately, whether they feel that there's an imminent safety risk to the community, or whether they think that waiting for some time and talking with him in a non-custodial situation where they don't have to advise him of his Miranda rights, and where he may feel more comfortable and willing and able to talk about the offense in a way where he doesn't feel that he's being accused of anything. Again, in that last webinar, we talked in detail about these things, so I don't want to go over it too much at this time. We talked about the pretext phone call and how that should only be done under the direction and supervision of law enforcement. I never advise our clients to do this on their own, but there are times when law enforcement may ask the victim herself to call the perpetrator, or may talk with the perpetrator ahead of time, again in an informal way, to see what they're willing to admit to up front. We talked about the conventional suspect interview, again, non-custodial if possible, preferably before the suspect knows of the investigation. We don't want to give him a heads up in time to develop his story. Oftentimes, defendants will provide a lot of information because they don't think they did anything wrong. They may downplay the seriousness of the offense, but they might fully admit that, yes, they had contact with the victim that day. And so a lot of the elements of the offense are already then agreed upon between the detective and the defendant or the suspect. The officer will then complete their final report, including all the narratives, statements, other evidence, and information that they gathered throughout their investigation. They'll provide that to the county or city attorney for review, and the prosecutor will then review the information and make a determination about whether they believe there is evidence beyond a reasonable doubt or a probable cause, at least at this point, to charge the defendant. Developing that relationship in multidisciplinary groups, in one-on-one interactions, in any way that we can have contact with law enforcement and become allies with them is so important. Before you even bring a case to them or have a client come in, if you and you as the advocate and the detective or investigator have a good rapport, understand each other's roles, and understand that you have different things and different goals that you're trying to achieve during your work with the victim, but that you can both assist the victim in moving forward, and how you can be a bridge between law enforcement and the victim and keeping them informed of what's going on with their case. Prosecution then gets the final report from law enforcement. They determine whether the elements, not elephants, I almost said it again. If you listen back in the first webinar, you'll hear that I said elephants. If the elements of the offense are substantiated by the information that's provided in the report from law enforcement, they can move forward with prosecution. If one element is not proven beyond a reasonable doubt, the jury is required to find the defendant not guilty, and under their ethical obligations, prosecutors are not allowed to charge those. They have to have the evidence and be able to meet the elements of the offense. Again, go back on those beginning slides, go through each of the elements of 1st through 5th degree criminal sexual conduct under Minnesota statute. The city or county attorney then again determines whether they're going to press charges against the suspect. They can either do it through a complaint or through a warrant. A complaint is sent out with a summons requiring the defendant to appear in court, and a warrant gives law enforcement the authority to pick up the suspect and hold them pending the first hearing. We talked about the pros and cons of an arrest, a summons, or a warrant, and why law enforcement or the prosecutors may make certain decisions in order to best secure the case and make it as strong as possible by the time that it moves forward through this criminal court process. The first hearings are the Rule 5 and 8, also known as arraignments. This is where bail is set. The defendant is advised of the rights that they have and the charges against them. This is where pretrial conditions of release can be made, where there's a no contact order between the suspect and the victim, or other conditions that they have to comply with in order to not be held in jail pending further hearings. Omnibus hearings, again, in review, are an evidentiary hearing that's focused on one specific issue. If the defense makes a claim that something unconstitutional or improper was conducted through the investigation, this is where they can challenge that or the constitutionality of the charges moving forward. It's very rare for a victim to be required to participate at this stage, but again, they always have a right to be advised and to be present if they so choose to do so. Sometimes they'll ask advocates to go on their behalf and to report back to them what happens, and often that's the role of the victim's witness coordinators or advocates in the county attorney's office to keep the victims appraised of that as well. If they don't want to be the direct person contacted, they can ask their advocate or other person in their life, parent, friend, significant other, teacher, to be an intermediary between that for them, so they don't have to have constant contact knowing what's going on. We talked about guilty pleas or plea bargaining, plea agreements made between the prosecutor and the defendant, and why that may be, in many cases, the best option available both for the defendant and for the victim. It keeps the victim from having to testify, but it also can be very harmful to the victim if they feel that the perpetrator is not sorry or not properly taking responsibility for what they've done. On the other hand, it can be very healing for the victim knowing that they don't have to testify and go on the stand, and hearing the person say, to whatever degree the defendant is willing to say, that they actually did it. It also makes sure that a conviction is entered and that some kind of a sentence is going to take place. Anytime that a trial is happening, both sides are basically gambling, never knowing what a jury is going to actually do. So there's a risk in going forward, and doing an agreement can secure the results that everyone's comfortable with. The pretrial hearing is simply an organizational meeting simply for the judges and attorneys to discuss witness lists, timings, progress made on negotiations and plea agreements, whether they think the trial is actually going to happen, and any pretrial motions or motions in limine that either party has filed. And here we are at slide 4, the beginning of day 2 of our webinar. Thank you for bearing with me as we ran through that first set of information really quickly. Ty, are there any questions at this point before we start the main part of this webinar?
Nope, but just a quick note, if you do want to listen to the first part of the webinar, it is up on our YouTube channel already, and it's titled, what's it titled, Amy? Criminal Law Sexual Assault for Advocates?
101.
101, that is the title, and it's part 1. And so this part 2 will be up next week.
Thank you. Okay, so we've gone through the formal investigation with law enforcement, the decision to charge, and we have a victim who's now at a place where trial is going to be starting, and they may actually be needed to testify. And so we want to go through kind of into the nuances and the weeds a little bit, some nerdy lawyer stuff about what the trial actually is like, what kind of things can happen. And then we'll talk about sentences that are available and what some of the nuanced words regarding sentences mean. This can be helpful just to have a broad context and understanding of what happens through the criminal process, but oftentimes victims aren't going to be to see their cases go this far. So again, like we talked about last time, a lot of the criminal process feels very tilted or in favor of the defense or the defendant. And under the U.S. Constitution, defendants have significant constitutional rights. Under the Minnesota Constitution and our criminal codes, they do as well. And so the victim sometimes can feel lost through that, and which is why it's so important to have an advocate and a support person there who understands the process and helping them through it. So once negotiations have failed, there's not going to be a plea agreement. All of the investigation and discovery has been done. We're at the trial stage. The defendant will determine whether they want to have a court trial or a jury trial. In general, the purpose of the trial is to resolve a dispute of facts. Either the jury or the judge observes the evidence presented, evaluates and weighs the evidence, and based on that evidence decides whether the defendant committed the alleged acts that are charged in the complaint. In a criminal trial, if the judge or jury finds that the defendant engaged in acts they're accused of doing, then the jury or judge also decides whether those acts satisfy the definition of the crime and meet all of the elements contained in the statute. A criminal defendant has the right to a jury trial, which is a jury made up of 12 persons, 12 of their peers if it's a felony trial, or 6 peers if it's a gross misdemeanor or a misdemeanor trial. Most criminal defendants choose not to waive their right to a jury trial and have a trial by jury, but sometimes they want to take their chances with a judge, and they have a right to have the judge decide the case rather than a jury. In cases where the trial is going to happen, the prosecutor may subpoena the witness, the victim, and require them to appear or testify. Prior to doing that, the prosecutor is going to be meeting with the victim, having ongoing conversations with them, talking to them about what the trial will be like, what kind of questions they're going to be asking, and we'll be doing a rather formal interview with them of the facts to make sure that they know that the victim is going to be able to testify about what happened, to help have that conversation ahead of time so the prosecutor knows that the victim is able to talk about it and how to best help the victim talk through it in front of a jury of strangers. Before the actual trial starts, jury selection occurs. The victim may be present for the trial. Sometimes witnesses are sequestered, and therefore, if the victim wants to be present for the whole thing, should ask the prosecutor if they can be the first witness so that they're no longer sequestered and able to observe the testimony of the other parties. The prosecutor ultimately will make that decision on their trial strategy and how they think the information should best be presented to the jury. There's several stages of the trial. There's pretrial motions that take place outside of the presence of the jury before the trial begins. Either the prosecutor or the defendant may ask the court to prevent the other side from being able to present certain types of evidence or to permit certain types of evidence. And these are called motions in limine, which I mentioned a minute ago. These motions are made outside of the presence of the jury, usually before the jury is selected, but sometimes after the jury is selected and prior to the starting of the opening arguments. If a jury is going to hear the case, the trial begins with the selection of the jury, which is a process called voir dire. The prosecutor and the defense may submit a written questionnaire to the jury pool regarding their past experiences with any offenses that the defendant is charged with. Jury selection is normally completed in half of a day, so usually in a morning or afternoon session before the beginning of the trial. Once the jury is selected, the judge will give the jury members preliminary instructions about their duties and roles and how they're not allowed to talk to other people about the trial and how they make independent decisions about what will happen. One issue that sometimes happens in the cases and with the victims that we work with is that as the trial nears, victims' trauma can occur and be significantly triggered again. Oftentimes, this process takes a year or more to get to the point of a trial, and the victim has had some time to heal and be away from it, and hopefully be working with a therapist and advocate and working towards healing the trauma. But as they meet with the prosecutor to prepare for testimony, or they think again about having to face that perpetrator in a courtroom, it's not uncommon for victims to change their story or to recant and say something wasn't true, or to not be willing to talk about the full incident of what happened. Oftentimes they have fear of retribution by the defendant if he's found not guilty, that I went in front of all these people and I testified and he heard everything I said, and then the jury said he didn't do it, and now he's free and he knows that I did that, and he knows more information about me if he's a stranger or a non-intimate partner. And so that fear of what he might do following that trial can be a catalyst to making them recant or not want to testify. They can be very scared of the cross-examination of what the attorney for the defendant is going to ask them or talk to them about. They feel that they'll be blamed or shamed. They may have even done something in the course of the events that makes them feel shamed themselves, and they don't want to be brought up. They don't want to be in the same room as the defendant. In a non-intimate partner or stranger kind of case, that they don't have a relationship with this person, the last time they maybe saw them was during a violent or even a non-violent sexual assault. Hearing their voice, hearing the defendant simply say their name can be triggering and traumatizing to the victim, because it's the first time they've heard that voice since the incident. So as advocates, how can we help? We can explain the courtroom setup. We can go look at the courtroom. We can meet with the prosecutor and try to develop a relationship between the victim and that person, so that when they're on the stand and they're talking to that person, they feel like it's somebody they know that they're telling their story to again, and that the prosecutor isn't some stranger or a foreign person that's suddenly asking them questions. And acknowledging to them that this is a scary time, and that you're going to be there for them, and you're going to be there for them after it, and that you believe them. And if they do recant and choose not to participate, again, we always want to give the client back their autonomy, and we can, as advocates, support them through that as well. And hopefully you'll have a relationship with them by this time that you're able to have deeper conversations about what's really going on and what they've told you in the past they want, and how you can best support them through that. So back to the trial. After the voir dire is completed, the jury is seated, we're beginning the actual trial. The opening statements take place. The prosecuting attorney gives his or her opening statement explaining the facts that the state expects to be able to prove throughout the course of the trial. At this time, the defense attorney can give an opening statement, or they can waive the opening statement altogether and say they don't want to give one, or they can wait until the state has completed their case and then give their opening statement at the beginning of the defense's stage of the trial. Opening statements may consist of simply a statement that the case is being presented and the facts that the party expects to prove. The prosecution then gives their case in chief. After the opening statements, they present the case by questioning witnesses and seeking admission of exhibits. The case in chief is the prosecutor's case. That's like the story of what we're telling you. The defendant or their attorney has the right to cross-examine each of the state's witnesses. And the defendant can also object to questions posed to the witnesses, to parts of their testimony, to the admission of specific exhibits, and then the court will have to rule on each of those. Usually in front of the jury, there are times when a break is called so that legal issues can be argued about out of the presence of the jury so that it doesn't interfere with their decision making. After the prosecution rests, meaning they have completed their case in chief, it's the defendant's turn to present witnesses. Almost always after the prosecutor rests, the defendant's attorney will make a motion to the court to dismiss the case based upon lack of evidence to go forward. That motion has to be done so that the defendant can raise certain issues on appeal, and it shouldn't be concerning to us or to the victim. The motion is almost never granted, but it's almost always asked for. Since the burden is on the prosecution to prove that the defendant is guilty beyond a reasonable doubt, the defense can choose not to present any evidence if they don't want to. The defendant has absolutely no burden to produce evidence, provide testimony, or do anything to show his or her innocence. They can simply argue to the jury that the prosecution didn't do their job, didn't prove the case beyond a reasonable doubt, and that they should find the defendant not guilty. The prosecution can object to questions the defense poses to its witnesses if they choose to call any, and can object to the defense witnesses' testimony and exhibits offered into evidence. The prosecution also gets to cross-examine the defendant's witnesses. After the defendant presents its case in chief, the prosecution can present more evidence in order to rebut the defendant's evidence. If the defense has provided evidence that the state can verify and prove is not true, that's when they present that evidence to show that there's been false information provided. After the state does that, the defense can offer additional evidence for the purpose of rebutting the prosecutor's rebuttal evidence. Fortunately, that's not usually allowed to go back and forth too long, and the primary evidence will have been provided in the case in chief. Once each side has finished presenting their evidence, the prosecution makes a closing argument or a summation of what the evidence shows and how the evidence meets the elements. Then the defense makes a closing argument, and the prosecution is permitted to make another final argument to the jury, but only for the purposes of responding or rebutting the defense's argument. Under very limited circumstances, the defense may be able to make an additional closing argument in response to the prosecution's rebuttal arguments, but typically the prosecution gets the last say. Before the jury leaves the courtroom to deliberate, the court charges the jury, meaning that the court reads to them certain instructions out loud and provides them with jury instructions in writing as well. The instructions are based on the statutes and some court rules and are intended to break down the legal requirements so that a jury understands what they must decide. The jury then leaves the courtroom to deliberate. So the jury instructions are going to contain the specific elements of each crime that the defendant is charged with and lay them out in a very simple way that the jury is able to understand. So there's several outcomes of a trial that can happen. The defendant can be acquitted, where the jury or the judge finds that they are not guilty of the offenses that they're charged with. This means that the prosecution was unable to prove beyond a reasonable doubt the elements of the offense to prove that the defendant is guilty, and the defendant is therefore not convicted of the offense. I would just note as an aside that this does not mean that the defendant is innocent. It simply means that the state was unable to prove beyond a reasonable doubt that he did it. And oftentimes the jury and the judge and everyone understands that, but recognizes that there wasn't sufficient evidence or proof to show it. So victims absolutely understandably can be very frustrated or traumatized or hurt after going through a trial and then having a perpetrator acquitted, which is one of the reasons that plea agreements are entered into, so that the prosecution and the victim are guaranteed a conviction of an offense. The second option that the jury can come back with is a guilty verdict, saying that the elements of the offense have been proven. At that time, typically conditions of release can be revoked and the defendant can be held until sentencing, or the defendant may continue to be released on the prior conditions of release and return for sentencing on a later date. A hung jury is when the jury is not able to make a decision unanimously whether the defendant is guilty or not guilty. In that case, the prosecution has to make a decision whether or not they're going to try the case again. Going back to the guilty verdict, the jury can be split regarding the charges, but they have to have a unanimous decision. So if there's more than one count that the defendant is charged with, they can find that he's guilty of count 2 and 3, but not guilty of count 1, and so he's acquitted on that charge. So sentencing is quite complex, and if you guys don't have questions in a little bit after I go through the summation, we can talk more in detail about it. But there's a very complicated set of legal authorities that goes into the sentencing. So it's always really important that we as advocates and even prosecutors avoid predicting what the sentence will be, because there's so much nuanced legal stuff that goes into that decision that we can't predict it. One of the outcomes can be that the defendant is placed on probation with specific conditions. To be placed on probation, they can be ordered to serve up to 1 year in the county jail. If they serve a year and a day, it would be a commitment to the Commissioner of Corrections, so they cannot serve more than 365 days in jail if they're on probation. The probationary period also may not exceed the statutory maximum sentence. So if a defendant could be sentenced to prison for 12 years for the offense, they can't be placed on probation for 15 years. The maximum amount of time they could be placed on probation is for the 12-year sentence. Alternatively, they can be sent to prison, which means that they're committed to the Commissioner of Corrections. That's any time that it's 366 days or more, a year and a day or more. The offender serves 2/3 of that sentence. For general crimes, the last third is served on supervised release, which is subject to revocation. So if you have a 12-year sentence, you would do 8 years in prison and 4 years on supervised release. And if you violated any of the terms of your release during those 4 years, you would automatically return to prison for the duration of the 12 years. And again, we'll get more into details about this if you guys don't have questions. So as far as advocacy applications for working with a victim through the sentencing process, it's important for the victim to understand the relationship of the victim witness staff person. And this is important through the trial, even prior to the sentencing. So the victim witness staff person at the county attorney's office is a supportive person and will be keeping the victim up to date on information. However, they're not a confidential advocate. If the victim talks to them or tells them information that's exculpatory regarding the offense or any factual information about the offense in general, that person has to tell the prosecutor, and the prosecutor is ethically obligated to notify the defense attorney. So it's important to understand the advocate's role versus the victim service advocate's role, and that the sexual assault advocate is confidential and that the victim can talk with them freely about their feelings and thoughts about the process that's taking place. It's important for us as advocates to make sure that the victim understands the reasons for each of the court hearings and how each outcome may affect her. It helps the victim to know how to report violations of the conditions of release. For example, if the defendant is ordered to have no contact with them or not come to their school or their place of employment, they need to know how to tell somebody if that happens. Also working with them, obviously, on the civil side about if there's any protective orders that they need in addition to the conditions of release that the defendant is on, and to help her address any concerns she has about the trial, answer questions, make her more comfortable, provide support in talking with the prosecutor or other professionals about the process. If a defendant is found guilty, a pre-sentence investigation or a PSI is completed by probation. A probation officer is assigned, and their job is to get a full picture of the offense for the court. They don't only look at the crime, but they look at the defendant and his background, what he's like as a person, and they look at the victim and their background and how this has affected them. They should be talking with the victim about what kind of outcome they would like to see or what kind of sentences they think would be appropriate. We don't always have non-intimate partner violence. Oftentimes this could be a family member or a significant other that has harmed them. And they might have really specific ideas of this person really has a drug problem, and if they don't get drug help, they're not going to be safe in the community. Or this person is a pedophile and has been since they were a teenager, and you need to know this history. However, when the victim talks with the probation officer, it's important for them to know that the defendant will be able to see in the report what the victim has said and what her requested outcome is. The report then has sentencing recommendations that's turned into the court. A formal report is written and given to both attorneys, the prosecutor and the defense attorney, as well as the court. Included in this can be the victim impact statement. This is when the victim services person from the county attorney's office would provide the form for the victim impact statement to the victim, where they're allowed to write essentially a message either to the court or to the defendant, letting them know the impact of this offense on them and their lives and what they'd like to see happen. That can be very healing and very empowering for a victim to not only write it, but if they choose to participate in the sentencing hearing, to actually read it or have it read on their behalf publicly to the court and to the defendant, so that the defendant has to listen to them and they get a voice. They get a chance to say, what you did has an effect on my life, and that's not okay. Once the sentencing is done, there's several different kinds of supervision. Probation is typically done at a county level. There are county probation officers. This can be done following a local placement if they're placed in a county jail for a certain number of days, up to 365 days, and prison is not imposed. All of the terms and conditions of their probation then are monitored by the probation officer. If they have gone to prison and served 2/3 of their time, that final third will be supervised release under parole. So there's a lot of confusion about the difference between jail and prison and probation and parole. Jail is local county level incarceration, and prison is a state level 366 days or more. Probation is locally monitored at a county level prior to a prison sentence. Parole is following a prison sentence. It's very, very important that we remember, and the victim will always remember, that not all of the perpetrators will go to prison, and that can be very frustrating and difficult to accept. It's also important to recognize that those that do go to prison will be getting out of prison. There are some cases where the perpetrator is found to be dangerous and is committed civilly to a hospital, or St. Peter typically is where they go. That's very rare. Those are very dangerous, untreatable people often. I think that's kind of strong. I think that The consensus is that they are treatable to some degree, but that they're not safe to be in the public and the community anymore. That's not the majority of cases. Our clients are going to have perpetrators who are going to be out again. And so even after the sentence, if a perpetrator goes to prison, it's important that we're continuing to work with those victims and supporting them and looking at what safety planning is going to look like after that person is released. So supervised probation on a local county level under a probation officer, the court sentences an offender to specific conditions. On a felony sentence, there can be a stayed prison sentence where the time hangs over the defendant's head. If they don't comply with the conditions that they're sentenced to, they could face going to prison. They can be placed on electronic home monitoring or incarcerated in a jail up to 12 months and continue on probation following that. They can be fined. The statutes have specific fines recommended for each offense. And the conditions are designed to support the defendant in getting the help that they need to prevent future offending. So if there's a concern that they're a sex offender, there is sex offender treatment, which includes a polygraph examination and lots of intensive therapy and requirement that they admit what they've done and come to terms with what they've done. Oftentimes, chemical dependency is a concern. They can be required to go to support groups or individual counseling. In domestic violence cases, there's batterer intervention programs that can help, peer programs that hold, where the perpetrators actually can do a really good job of holding each other accountable because they know what they've done. And then the punishment part, which is separate from the rehabilitation part of the probation, can be the fine or the incarceration. So there's two parts to the sentence that the defendant is going to be engaged in. So what does this mean for victims? The victims should be notified at the time of the pre-sentence investigation. And they can request to be notified anytime that a defendant is released from any kind of incarceration or moved from one facility to another. That's on Vine, and we'll talk about that in a little bit. And victims have rights. The Office of Justice Programs through the Minnesota Department of Public Safety has a really good reference guide for criminal justice agencies and professionals. All of you should go online and download this. It's the Minnesota Crime Victims' Rights, and there's graphs that lay out the definitions and the specific statutes that apply and what rights victims have at each stage. What do they have the right to ask for from the court, from the prosecutor, from law enforcement, from probation, from custodial facilities, from the prisons themselves, and from other people, the Department of Human Services, their employers, landlords. And so again, this is OJP, the Office of Justice Programs through the Minnesota Department of Public Safety, online has the Minnesota Crime Victim Rights Act, which is super handy to have a copy of. So when victims are asking us, what rights do we have? What can I do about this situation? It's super handy to pull that out and be able to answer that for them. So again, Vine is the victim information and notification every day. It's a 24 access to custody cases. So advocates can register for it, victims can register for it, family members, anyone who wants to be notified, typically by email, anytime that a defendant is moved so that they know where they are. It's important that we recognize and help the victims to understand that the probation agent is not the advocate for the offender. They are to hold the defendant accountable, but they're also not the advocate for the victim. Their job isn't to make sure that the victim's rights are protected. Their job is to ensure community safety and make sure that appropriate sanctions and supervision are made over the defendant to make sure that the community remains safe. The pre-sentence investigation report should be impact gathering. So talking to the victim about how has this affected you? What would make it better? How can we restore things? It's not an opportunity or a requirement for the victim to retell the story, have to talk about what happened to them unless they want to. It's not the role of the probation officer at that point to reassess the guilt or innocence of the defendant. That stage of the process is already done and they're convicted and guilty. And so what are we going to do moving forward to keep the victim, the community, and society safe? Probation agents can be the easiest and quickest way for a victim to get information about the status of the perpetrator and what kind of programming they're receiving, how they're doing, if they feel that the victim is safe, or if there's some pretty serious concerns that the agent has that the victim should be aware of, to have all the information available to her prior to making ongoing safety planning. I can go through in more detail the sentencing options and what some of the terms mean. Again, it's kind of nuanced.
Yep. Amy, before you do that, I just want to chime in that the Vine link, that one is victim notification for victims of a crime who are in a jail or detention facility. But for the ones that are in prison, that is to get notification, that's Minnesota Choice. Correct, Amy?
Thank you, Ty. Yep. Mm-hmm. Vine is for local jails.
Yeah. Mm-hmm. And so the Minnesota Choice is the one if a person is in a prison facility, and you can go online and it's minnesotachoice.com, or there's an 800 number, 1-800-657-3830, where you can call and get more information on how to sign up to get notifications on that. Same as with Vine, it's VineLink, VINELINK.com, but they also have a 1-800 number as well, which is 1-877-664-8463, and you can use either the online link or the phone number to get to sign up to get notifications. But I also have a question, Amy. If you don't have anything more to add to that, I have a question.
The only thing I wanted to add to that is that there's also online, if you don't want to get ongoing notification from a person who's in prison, if they move from one prison to another, but occasionally the victim is curious, you can go online through the inmate offender locator, I think through the DOC, Minnesota DOC. So that's another option if they don't want to have constant alerts. Mm-hmm. Again, what I have left to go into is really in the weeds, nerdy lawyer stuff. So if there's questions, I'd much rather talk about that.
Mm-hmm. Well, there is one question so far. And if people have questions now, go ahead, type them in, and I can let Amy know about them. But there is one question so far, and that is when sentencing is not what the victim was expecting, what are options that we as advocates can discuss or give to the victim?
Hopefully, sentencing is not going to be a surprise at the time of the sentencing hearing. Hopefully, the prosecutor or somebody will have told them what the recommendations are going to be or what they suspect will happen. However, it is common for a defense attorney and a probation officer and a prosecutor to all go in with 3 separate arguments to the court of what should happen. And ultimately, it's up to the judge to make the decision regarding sentencing and to make findings of why they deviate upward or downward from the sentencing guidelines. There is a tool that they use based on person's prior offenses and convictions, the severity of the offense, and the impact on the victim that they're supposed to follow these guidelines, but they're pretty wide ranges of time in prison if it does rise to the level of a prison sentence. And so just advising the victim ahead of time that you don't know for sure, nobody knows for sure what the judge is going to do. Even if the probation officer, defense attorney, and prosecutor all walked in front of the judge in agreement, that doesn't mean that the judge has to do that. So warning her ahead of time of that, I guess, would be helpful, but then also helping her to make sure that her voice is at least heard through a victim impact statement or their interview with probation to talk about what they think is important and why. Unfortunately, after the fact, there's not a lot that can be done about it. The victim is not a party to the case and doesn't have a right to appeal or anything, but there are other forms of assistance civilly available to victims, whether or not there's a conviction, such as reparations and restitution and other options like that. I hope that answers that question. Is there a follow-up?
There is not a follow-up question to that, and there aren't any other questions so far, Amy. So if you want to go ahead and talk a little bit more.
Okay. Feel free to interrupt me if anything comes.
Okay.
So stay of adjudication is a term of art in the legal field that requires a defendant to plead guilty. With the stay of adjudication, the court agrees not to enter a judgment that the defendant is guilty, and the court's decision not to adjudicate the case means that the court is staying or delaying the entry of the conviction on the record. So the defendant comes in, pleads guilty, and the judge accepts the guilty plea, but doesn't convict the person at that time. So they're not adjudicated guilty. It's a stay of adjudication. The stay of adjudication is contingent on the defendant's compliance with specified conditions, which are generally monitored through the defendant's service on probation for a specific period of time. So you're on probation for 4 years. These are the things you have to do. If you do all of them, you're never going to be convicted of the crime, but you've had some consequence. If you don't do all the things that you're supposed to do on probation, then the defendant can be brought back into the court and the judge can enter the conviction based on their prior admission to the facts. And then they can sentence the defendant after that time. A continuance of dismissal is a different kind of a plea agreement where the court agrees to continue the case for dismissal, meaning that the defendant does not make any admission of facts. They don't plead guilty or say they did it. And it's based on the recommendation of the prosecutor. In agreement with the defense attorney, the court orders the case continued for a specified period of time, but the defendant again has to comply with certain conditions during that period. So the defendant usually serves probation during the period of the continuance, and the probation officer monitors the defendant's compliance with the conditions. And if they follow everything they're supposed to do for that period of time, then the case is dismissed outright. And if they don't comply with the conditions, then it's brought back into court, but they're not convicted. Then it starts all over and they're at a place where the prosecutor can then prosecute the case. You had a chance for this to all go away if you did ABC. You didn't do ABC, now we're back at the beginning and we're going to prosecute you. A stay of imposition versus a stay of adjudication is where the court is sentencing an offender to probation instead of prison. And one option is to stay that imposition. So this is normally the option used when the sentencing guidelines presume probation as the sentence. So in staying imposition, the court does not pronounce how many months of prison the offender would ultimately receive, but simply places the defendant on probation for a specified number of years up to the statutory maximum. The court will then set a number of conditions of probation which the defendant has to follow. If the defendant doesn't follow those conditions, they can be brought back for further sanctions, which can include being sent to prison. The prosecutor and the defense attorney are free to be creative in negotiating these conditions so that they address the defendant's situation and the behavior, as well as the victim's concerns. By law, if a defendant successfully completes probation, their felony conviction will be changed to a misdemeanor conviction, and for some purposes, it won't be considered a convicted felon. So here's another stay. We have stay of adjudication, stay of imposition, and stay of execution. A stay of execution is similar to a stay of imposition in that the defendant will go on probation with specific terms for the duration indicated by the court. However, with a stay of execution, a specific number of months in prison will be determined by the court at sentencing, and these months hang over the defendant's head while they serve out the probationary period. A stay of execution is often imposed when the sentencing guidelines presume prison is the appropriate sentence, but the court is giving the defendant a chance to see if they can succeed on probation. The biggest difference from a stay of imposition is that here the defendant's conviction always remains a felony conviction, even if they successfully complete probation and never go to prison. Execution of the sentence is the most severe, and that's when the court actually sends the defendant to prison on a felony offense for a specific period of time. And execution can occur immediately upon the initial sentencing of the defendant, so after their plea hearing or after they're found guilty at trial, or if they have been placed on a stay of adjudication, stay of imposition, or stay of execution, we're now at the fourth violation hearing, and they've failed to fulfill the terms of probation, and now they're being sent to prison. So when the defendant's sentence is executed, they'll be transported by the Minnesota Department of Corrections within a few days of the sentence being pronounced. The actual prison where the defendant will be housed is determined by the Department of Corrections after they're processed in general through the facility in St. Cloud, which is where all the intake processes take place. When the defendant's sentence is executed, he or she will receive credit for any time spent in jail or a juvenile facility, but not for electronic home monitoring. And this goes all the way back to the date that the probable cause was determined and the defendant was charged. So if they've been on probation for 10 years and during that time they've served 60 days here and 30 days here for other things, even if they're not related to this charge, they still will get credit for that time served. For example, if jail credit was for a DWI, it would still apply to their prison sentence for a sexual assault if the jail time was served since they have been charged with this sexual assault. That is all I have.
I have a question.
Great.
Yeah. Okay. So there's a comment. Do you have a handout, Amy, with types of court hearings and what is expected to happen at those court hearings? Do we have something like that created that we can send out?
Like a one-page thing?
Well, it could be a one-pager. I think what they're looking for is just a handout, just something where they can easily look, a cheat sheet possibly, of the different types of hearings in a court process and what happens at those hearings, and also the sequence of hearings. What happens? You kind of talked about it, I think, but is there anything where it's like in a cheat sheet?
It is in the PowerPoint, kind of in order, but no, I don't have a cheat sheet, but I can certainly create one if they'd like. I'd be happy to send one out.
Yeah, and then I can, yeah, if you want to, obviously it's going to take maybe a week or two, but when you get that created, you can send it over to me and I can send it out on the listserv as well, Amy. I think that would be helpful. And then a follow-up to that, I think this is another question is you talked about the different stays. Is there a website that people can go to get more information about that? You went over it pretty briefly.
I can also do a cheat sheet on that and kind of lay it all out. I don't think there's a website. It might be in the Department of Corrections information somewhere, but I dug it out of the statutes.
Okay. Yeah, I think that's a lot of helpful information. I mean, I know when I was doing advocacy, it's hard to keep the hearings and stuff, you know, just to keep on top of like what happens at what hearing and those things, so I can understand the request for that. I had something, I don't know where I got it from. I don't remember where I got it from, but I remember I had something in my office where I had access to just to look at that as well. But I don't recall where I got it from now. But I know it is confusing.
Yeah.
So,
I was a prosecutor for 10 years and it's still confusing to me.
yeah. Well, I don't have any other questions other than that. Um, so I think it's perfectly fine. If usually our webinars are 90 minutes, but this is a part 2 to the one that we did earlier in July, and we didn't have enough time to finish that one. So I think it's perfectly fine if we end the webinar now. But since we do have time, I'll just put in a quick plug saying that I am creating an evaluation about our webinar series, and I will have that out and sent out onto the listserv by the end of this year. And that is just to gather feedback from all of the advocates that listen to our webinars, to see, what your thoughts are on the webinars, if there are things that we can do better, and all of that. And so it's a brief, it's not even 10 questions. I just created it today, but it's not even 10 questions, but it will really help us in making the webinar series better for advocates. So please take your time and take a couple moments of your time and fill that survey out for us, because it would be really helpful.
Thank you so much, Ty. Thank you everyone for joining us today. Always, we are here to answer any questions. So if you didn't want to pose them on here, but you have them, feel free to call. And happy holidays, everybody, and have a great day.
All right.
Bye.
Bye, everyone.